pretty quickly. And then anything over that is going to get taxed at 55% tax rate. So they've already taxed you on income tax, any kind of capital gains from investments, and they're going to get you at the end 55% over anything over 650. So realizing that that might not be an easy situation for people to deal with, the federal authorities kind of increased that gradually until very recently. So there was a step up in that exemption. So 2004, it was 1.5 million. 2009, 3.5 million. 2010, actually, if somebody was lucky enough to die in 2010, there was no federal tax going on their estate. And then until recently, it was about 5.5 million. Now with the new federal tax laws, it is over 11 million. So a married couple could have up to about pretty close to $23 million in their estate, and they wouldn't have to pay a cent of federal estate tax. However, Illinois hasn't changed. That has been at about $4 million for a pretty long time. The rate it varies, it's up to 16%, but Illinois estate tax might be something you need to factor into your plan, even if federal thresholds are not going to apply. Similarly with federal law, you can double up on the marital tax exemption, so husband and wife having $8 million can get out of having to pay any kind of state tax. So that's the change in the thresholds for federal taxation. Portability was a new law in 2011. And what that does is it allows a married couple to use that doubling up without having to do anything formal, really, on the event that the first one passed away. Before portability, you had to set up a separate trust. You really had to document that there is a completely separate trust now, which used up the first tax exemption, and then the surviving spouse gets to keep the second one. Now it's a little bit different. You still have to check a couple boxes on a tax form. If you have a trust, the trust still has to allow for portability, but it's a much simpler process. So it makes the planning a whole lot easier. The only problem here is that Illinois doesn't have portability yet. So it could, even though it still helps you out on your federal tax return, if you're close to that $8 million threshold for Illinois taxation, you'll still have to do some planning within your trust to make sure that you can use the Illinois payroll tax exemption. Gifting. This one's also in the news a lot, sometimes for good reasons, sometimes for bad. The reason that there's a gift tax is that if someone had $100 million and they were hospitalized, they were on death's door, if there were no restrictions against gifting, they could just say, well, I'll just gift everything right now, sign over a deed to everything, and then my heirs won't have to pay any kind of estate tax. So the rule is that any gifts up to $15,000 are allowable, and then anything over that amount, there's no tax immediately owing, but that will bring down your tax threshold. So if you have $1 million gift, that will bring down your federal tax exemption from $11 million to $10 million. But now it used to be, a couple years ago, $13,000. It creeps up gradually. Now it's at $15,000. And a couple points to make about gift tax and allowable gifts. So both a husband and wife can make gifts. They can both make that same $15,000 gift, even to the same person. The recipients can be related. So as an example, if you had a husband and wife and they've got an adult child who's married with 3 kids, then you can have each of the husband and wife giving 5 separate tax-free gifts of $15,000. So increasing that $15,000 to a gift of $150,000. And then there's other kind of advantages too. You can, if you're setting up a 529 college savings plan, you can kind of prepay that 5 times over. So you can make a $75,000 contribution to a 529 plan. And sometimes oversized gifts are okay. Again, you're not going to have to pay any tax immediately. And you wouldn't have to unless your ultimate estate is going to be over the federal threshold of $11 million. It's kind of complicated, but for Illinois, sometimes you want to gift over the $15,000 threshold which can be advantageous for planning out that estate strategy. Again, no tax can be owed at the time of that gift.
I have a question.
Yeah, absolutely.
If inheritance tax is inheritance is non-taxable, why would you worry about gifting?
Sure. So the question is, if inheritances aren't taxable, why would you worry about gifting? And the reason is because you're taxed at the estate level. So once the property goes from your estate to your heirs aren't going to have to pay any taxes, but your estate might have to. So if you do a gifting strategy, then to reduce your estate to just right about at that threshold, that's where that would come in handy. So does that help?
Okay, so if you're not going to be near the threshold,
that's a great point.
like the $4 million for the state, then you're okay.
Yeah, go nuts. I mean, at that point, you could give $50,000, $100, or whatever. If you know that, given where I'm at right now, I'm never going to get to that $4 million. You can just, give a gift and whatever. You could give somebody a house. You could just sign your house over if that's a gift. You would have to fill out a federal gift tax return, but that's just something for the IRS to kind of keep track of your estate. You just file a paper, they keep track of it, and then at the end, if you're not a taxable estate, it doesn't matter. It doesn't matter if there's no tax.
Thank you.
So, well. Okay. So real quick about Medicaid and other benefits, there was a federal law called the 2006 Deficit Reduction Act, which took forever to actually apply in Illinois. Medicaid is a federal law which also has some interplay with state law. So the Fed said in 2006, all the states have to start processing Medicaid applications in a particular way, which will have the effect of reducing the federal deficit. It didn't work. The deficit still is climbing at a pretty ridiculous pace. But the rules are now taking effect in Illinois, and they make it tougher to apply for Medicaid. They make it tougher to get long-term care benefits. The main point on that is that it used to be that you could put all your money into a trust and then still have some control over that trust and then apply for Medicaid to get long-term care and to have that paid by the government. It's not really possible anymore. If there's any kind of trust which you've got any control over whatsoever, they're going to say, well, you need to spend that trust down before you can get long-term care. So it's still possible to use trust as a way to plan for Medicaid. But if you have a regular revocable living trust, which is what is ideal for just regular estate planning purposes, that's going to be a problem when it comes time for long-term care. And then Social Security disability, it's not really something that you plan for in terms of what your estate's going to look like, but it is almost now impossible to get Social Security disability benefits within the first couple years of applying. So if that is something that you're facing, that someone in your family is facing, just don't count on it, avoid it if possible. It's an absolute nightmare. And both of these problems they're compounded by Illinois being absolutely dead broke and not having any money to staff for Medicaid or to hand out. So it's really difficult, and they're being pretty aggressive in terms of trying to claw back funds. If Medicaid has paid out benefits, if you've been on long-term care, after you've passed away, they can make a claim against your state for the benefits that they've paid out to you. That's happening more and more often. So again, because Medicaid is making claims against your estate, it's a good reason to not have a probate estate hold it. If there's a probate estate, they're going to sink their teeth into that and try to get whatever they can. If things are administered privately through a trust, they're going to have to do a little more legwork to actually take the money from your estate. So, since we're on the topic of how the state law works, here are the main documents we're going to go over. Most of them pertain to trusts, so there's now a trust protector, which is kind of a separate safeguard within a trust. A certificate of trust, which gives a little bit of privacy, so you don't have to turn over the entire trust document. There's a new small estate affidavit. There's been a transition from the old DMR to a new form called a POLS, POLSD. There's new powers of attorney. There's also something called a transfer on death instrument, which is kind of like a deed that transfers upon death. And lastly, there's going to be a completely brand new Illinois trust code coming out next year. The law's already passed, and it'll take effect on January 1st. The trust protector. This was something that was just signed into law a few years ago, but it was already in existing practice in other states and kind of been tested out in Illinois. The trust protector is a fiduciary, it's a representative that would be named in your trust, but it's somebody different than your trustee. The trustee would handle the day-to-day work about who gets what. The trust protector is there to provide oversight on the trustee. Since the trust is operated and administered outside of court, in court you would have a judge who kind of looks over everything. You've got lawyers who are going to be, hopefully not fighting too much about everything. But a trust protector is the person who would give a little bit of a backstop and some assurance that the trustee is in fact doing what you've nominated them to do. Usually the trust protector would have defined responsibilities. Let's say, before my trust closes out, I want my trust protector to sign off on that, or before any distributions of over $50,000 are made, before any real estate is transferred, before any businesses are sold, then my trust protector has to approve of my trustee's decision. It can be anybody, but it's usually a financial advisor or attorney because they might already have an existing relationship, and you can probably get them to serve free of charge. If a financial advisor is already taking commission, if an attorney is already a retainer, then they can provide that. In my opinion, should provide that as an additional service, just completely gratis. The advantages for a trust protector is that it can head off or even shorten a court battle. If the trustee knows that there's oversight, even if the trust protector doesn't have to do anything, just knowing the trust protector is out there might make the trustee less inclined to kind of push the envelope in terms of interpreting what they can and can't do. The certificate of trust is also relatively new, about 2015. It's a short form of the trust which gives banks and any other financial institution the information from the trust on a need-to-know basis. Most trusts are getting pretty lengthy these days, so the certificate distills the information from the trust and keeps your most private information private. If there's details of the trust about somebody's disability or a particular family member being disinherited, you don't want that to get out. The certificate just says, I have a trust, here's when I signed it, here's who my trustee is, here's their address, here's the trust's tax ID number, and if you want, you can kind of lay out the history of the trust. So I was the trustee, and then I resigned on such and such date, so-and-so passed away, and now the person presenting you with this document is legitimately the currently acting trustee. It's okay to deal with that. The small estate affidavit can be pretty helpful, especially if you do have a trust set up. Any assets that you got in your own name at the time of death, so ideally everything's in the trust. If there are certain things that aren't in the trust, if they're in your name after you passed away, those formed a probate estate. And it used to be that any probate estate over $50,000 had to go to probate court. The problem with that was that $50,000 really isn't, it's nice, but it's not that much these days. If you've got a revolving checking account of, let's say, $10,000, you've got a new car of 30 or so, and then you've got some miscellaneous odds and ends, you might have a burial policy, you can get to $50,000 pretty quickly. And then if you go to probate court, you're going to have to pay an attorney, you're going to have to pay court costs and fees, you have to publish notice. There's a lot of carrying costs that come along with the probate estate that would be ideally avoided. So now that limit has been bumped up to $100,000. There's different kinds of small estate affidavits. There's a particular one that the Secretary of State uses, which is slightly different from ones that banks will use, which is kind of annoying because it's supposed to be simple. It's supposed to be a self-help process where you don't have to get professionals involved, or the bank can accept it. You don't have to get directories involved, but unfortunately, you tinker with one thing, you try to bump up that limit to $100,000. They tinker with other stuff, and now it's getting to be a little bit longer. So it's still a good thing to have, but hopefully, you can avoid it if possible. But it is a good fallback. So that deals with a lot of the financial issues. Now, in terms of healthcare, there's still a DNR form, but now there's something new called a POLS, which is physician's orders for life-sustaining treatment. The difference between this and DNR is a DNR is similar to a living will in that it just said it's you speaking directly to a doctor, to first responder, saying, I don't want to have any kind of heroic life-prolonging treatment if it's not actually going to cure me. If it's just going to delay the inevitable, I don't want to be intubated, I don't want anything like that. The POLS is actually a standing medical directive where a doctor signs off on it, obviously consulting with you, so you sign it, the doctor signs it, so it's kind of an indicator to the world as to what your wishes are for particular instances of care. It's a little more detailed than the DNR. A good idea to have, but it's not really a necessity unless there's a serious chronic illness that could result in death. Until you get to that point, having powers of attorney or just having a standing DNR is probably okay, but a POLS is something that should absolutely be considered in the appropriate circumstances. And on that point, again, powers of attorney can do most of what a POLS will. So it's definitely good to have powers of attorney. They're probably going to be used a lot more than a DNR. And they can actually take care of what a DNR would do. They don't speak directly to a healthcare provider, but they will appoint an agent, a family member, husband, wife, close friend, who knows you, who you trust, and who knows what your decisions would be, and can speak to somebody else on your behalf if you're not able to. So again, there's two kinds of powers of attorney. There's a property power of attorney, otherwise called the financial power of attorney, and a healthcare power of attorney. The last big change for the property power of attorney was in 2015. There are just more protections for the person who is signing it. There's some warnings to advise you that be careful, this is a legally binding document, and there's also a place to get specimen signatures. So not a huge change. Healthcare power of attorney had a little bit of a bigger change. It was in 2016. There was an option for when you want the power of attorney to take effect. One of it was on incapacity right away. Another option that they give you is whether you want to have life-sustaining treatment. And the change there was that it wasn't just an A or B situation, that there is kind of a middle ground now where you can rely upon the doctor's opinion as to whether what end of life care would be appropriate, and that even if the power of attorney isn't triggered, even if the agent doesn't know if you're incapacitated, then they can work hand in hand with the doctor to get that determination. There's other minor legal tweaks that don't really have much of an effect on the planning side. But one takeaway here, probably more important than any of this stuff, is that powers of attorney, the form is going to look different. Even if the actual words in there and the legal stuff on the inside, the substance, even if there's not that much of a change, there's a lot of people in the medical industry who might not have seen the older forms that you've signed. So, God forbid you get somebody there who's, a nurse who's even younger than I am, they might not have seen a typewritten document. They might have only seen the power of attorney that's from 2015, 2017. So those are a good idea to get updated, even if who you want to have act on your behalf hasn't changed. And then a completely new document that came out a few years ago is the transfer on death instrument. It's kind of similar to a transfer on death designation in your bank account. If you want to say, okay, after I'm gone, I want so-and-so to have complete access and ownership of this account. I don't want them to have to go through probate. I want my son or daughter, husband, wife, member, to have this bank account. So you can set up those designations for investments, for bank accounts, and now you can also set it up for real estate. So if you report a transfer on death instrument, you're still the owner of the property, and until you can revoke it, you can change it, you can get rid of it or change who your beneficiary is going to be. And they're nice, they're pretty flexible. it's not just that you have to name one person, you could name a couple people. You could name, son and daughter-in-law, or you could name, 3 kids in equal share. So there's really a lot of options, and you can kind of do some really nice estate planning with the transfer on death and surrender. It will protect against estate claims because it will avoid having an estate being open. If a creditor, like let's say there's Medicaid, which is paid out $100,000 on your behalf for medical care, if they don't do anything in your lifetime, they can't come after your estate, the house, because there is no house. So kind of a nice planning tool for the home or for a vacation home that you might want to safeguard and keep within the family. However, you do want to proceed with caution here because it will be completely separate from a trust. If there's a transfer on death designation and you have a trust set up, those two things are going to have to make sure that they're both operating harmoniously. That if your plan was that everything is going to go to these people over here, your transfer on death instrument says no, it's going to go to somebody else, you've got to make sure that all matches up. And lastly, so those are the recent changes. Now the change coming up on the horizon is the Illinois Trust Code. Why they did it, it's probably because there were things like trust protectors and certificates of trust that were really good ideas in other states that had helped out a lot, but hadn't been implemented here. So it really beats having to do these piecemeal updates all the time. Now they're adopting what's called the Uniform Trust Code, which other states have implemented. There's a lot of good ideas and techniques in there with the overall goal of just making things simpler, giving people more options. It's also going to provide more guidance to trustees, to other fiduciaries and representatives, to attorneys and CPAs, because there's going to be a bigger body of law out there. Right now, there really isn't that much case law interpreting what the Illinois statutes provide. So if there's a lot more room for argument and debate over things, what that leads to is more fighting, more discord, more court battles, more costs, more attorney fees. It's longer and more expensive for things to get administered, which really shouldn't happen. So I'm pretty optimistic. Again, it's not going to solve everything, but hopefully on the margins it's going to make things better and easier. One thing it's not going to fix, though, is that your trust is still going to be the main document here, and that anything in the trust is going to take precedence over what's in the new law. So you don't just want to rely on what the new law says, what you've heard about it. It's still fundamentally important to make sure that your trust and your estate plan documents are clear and say what you want to happen. So that's sort of the changes in federal law, changes in state law, and we're going to go into how things actually work in practice and what's changed. If you've administered, if you've been the trustee or the executor of an estate in the past 15 years, and if things are changed, it's different. And then there's also some changes in legal theory to sort of how lawyers and judges approach these kinds of things. Changes in the law, the one thing that I've seen a lot recently is that there's no more land trusts. There's not as many irrevocable life insurance trusts. These were kind of creatures of the old federal estate tax system where, if you can only have an estate of $650,000 before there's going to be taxation, you're going to want to set up these little, almost like mini corporations, which are going to be outside of federal estate tax. And so you can put your house into a land trust. You can put your earnings into an irrevocable life insurance trust, which won't be subject to federal taxation. Again, those things are great. They were great at the time, but they have carrying costs. A bank or a trust company is going to make money off of you for a land trust. Your insurance company is going to make a lot of money off of you for a life insurance trust. And there's also, lawyers and accountants have to get involved. So those are great ideas then. They're still okay, but estate planning now would get away from that. And usually just using a revocable, not irrevocable, so a changeable living trust. And in terms of living trusts, now there's more individual trusts. So instead of a family trust or a dynasty trust, each spouse would have their own separate individual trust. It tracks better for federal tax purposes, and especially if now that income taxation and capital gains taxation are more important, they'll help you save on those. There's fewer joint trusts. Also, estates and trusts are now written, I think it's the big improvement, they're written in plain English. There's no more, there's a lot less Latin involved, there's less legalese, there's no, party of the first part, party of the second part. That's kind of all gone by the wayside. The downside is that when you do use plain English and you kind of spell things out, you give your trustees some details and guidance which they can actually follow in a format which is nice and easy to read. It's longer. So you might have a trust that's 30 or 50 pages. It doesn't really mean it's complicated. It just means that it's spelled out in rules that are easy to follow, easy to read. And probate, this is a huge change. This is just about the past couple years. It's gotten a lot easier. There are some probate cases where you have to file documents with the court, but you don't ever have to show up. If all the paperwork matches up, the judge will take a look at it. We email him a copy of everything, we file it, he signs off on it, sends everything back to us. Give the executor their paperwork. They're off to the races. They send out notices. They get receipts from everybody when everyone's got their money, and then it's done. So if there's not a fight, if everybody gets along, probate's pretty straightforward. It's still better not to go to probate, but if you do have to, it's a lot easier. It's more straightforward. You don't have to put up a bond. You don't have to have supervised court administration of anything. Everything's done electronically, remotely, again, assuming that there's no dispute. If there is, then it gets messy. And one of the ways in which that has gotten messy is that there's more creditors these days. There's a lot of debt collectors out there who buy up credit card bills, medical debt, unfortunately even more so than that, and then Medicaid itself when they claim against the state. So that is a downside. The good side is that most creditors know absolutely nothing. They don't know what they're doing. They'll send you a lot of bothersome notices, but they won't actually go through the trouble of prosecuting their claim in probate court. So generally that gets wiped out, but it is something that unfortunately happens. And finally, another way to get around probate is sometimes you can play ball with title insurance companies. If there's a house that you forgot to retitle into your trust, and it's very clear who the heirs and beneficiaries are, sometimes you can just get a kind of rider on title insurance policy, and then the title insurance company won't require that you go through probate to get the deed. So usually you would have to go to probate, you'd have to get the judge to give you letters of office to act on behalf of the estate. Then once you get that, the estate closes, you can sign off on the deed and give the house to whomever's entitled to it. But now the title insurance companies, because of the real estate crash, it's coming back, but they're looking for opportunities wherever they can find them. And as a result of that, and the competition between title companies, they're more willing to provide some additional services, which can be pretty helpful. And then one thing that kind of was left on the cutting room floor, if I had room for an E, what that would be is long-term care insurance. That used to be a big planning technique that you could buy an insurance policy which would help you plan for long-term care and would defray some of the costs of nursing homes. That's pretty difficult to do that. The policies that are, if you have a policy, absolutely keep it in place because it's going to be a great deal for you. If you don't have a long-term care insurance policy, you can look around, but they're generally not going to be a good deal these days because long-term care is now a lot more expensive, and if there is a policy that you find, it might look good on the surface, but there will be a lot of limitations in terms of lifetime benefits, how much they'll actually pay out. They might only pay, half of what the actual daily rate is at the long-term care facility. So, it might be a good idea to take a look, but be very careful before actually buying one of those policies. So, just kind of summing everything up before we get to the questions and answers. So back then, 15, 20 or so years ago, taxes were almost going to be inevitable. Not always that you would have to pay federal or state taxes, but it would be something you would absolutely have to consider. If you had the means to, have an accountant, to pay an attorney to draw up an estate plan for you, chances are you were going to have to consider that $650,000 threshold. And then the problem is that if you messed up, if there was something that went awry, there were going to be big-time consequences. So if you didn't have your trust set up in the proper way, you couldn't you couldn't, like portability as an example, and a husband and wife might have some taxes owing that they wouldn't have anticipated. So this did the land trusts and the irrevocable life insurance trusts that we've gone over, and again, those have carrying costs. So that's, that would be kind of the stereotypical, upper middle class estate plan of 50 years or 20 years ago. Now there's a lot more options. You can avoid pretty much ever having to pay estate tax absolutely on the federal level. On the state level, again, there's ways to deal with that. So generally speaking, state estate tax is something that can be avoided too, even though the threshold is a lot lower. Still pretty high, $4 million, $8 million for a married couple. So there's ways to play around with that. Any kind of gaps in your planning can be fixed, mostly. If a house doesn't go into a trust, which ideally it would, the title insurance company can help out. If you haven't set up separate trusts between husband and wife, you can still elect portability. So it's sort of in the trends that there's just more flexibility, more ways of stopping these gaps and providing some assistance. And soon, kind of where things are going in the future, again, with the new Illinois trust code, there's going to be even more guidance that's going to help you craft individually tailored solutions. And the most important thing, obviously, is making sure that you get your wishes down on paper. But when you do get to that point, there's going to be a lot more options available to you, more guidance for you in setting it up, and more guidance for your representative, your trustee, your executor, in terms of carrying out your wishes. So a few takeaways here. One, you want to avoid surprises, both in terms of what the law might provide, because there's changes in the law. Just try to keep up to speed on that if possible. Again, what you'll hear about is just the federal law, so that'll inform you about taxes. Generally, that's why it's a good idea every 5 years or so, kind of keep up to speed on what's going on with your estate plan. Second takeaway here is there's lots of options. You can always change your estate plan unless you have an irrevocable trust, and even then, just because it says irrevocable doesn't mean that it's got to stay that way forever. There's almost always something that you can do on the margins to make things better, even in a difficult situation. And lastly, kind of going back to the first one, change is constant, both in your life, in your family, your health situation, your investments, and also the legal situation. Things might change slowly, but they kind of come in fits and spurts. Like the federal tax law that just changed is a huge change. Illinois trust code, that's a big change too. So sometimes there's just these changes in the margin, sometimes there are big changes with changes that you should expect. So just keep an eye on things. If you have an estate plan, that's great. It's still going to be valid. Just keep an eye on it. So I think that's pretty much all I've got to say for my spiel, but we've got 15 minutes or so for questions. So yeah, sir in the front.
We're planning on doing an estate plan soon. Would it be better to wait until next year when the Illinois Trust Code goes into effect?
Yeah, that's a great question. So so the question is, if you're considering an estate plan now, would it be better to do it in 2020 when the new trust code goes into effect? And you could do it that way, but the good news is that we already kind of have the language as to what the law is going to look like. So you could still do it in the next few months in the fall or early winter of this year, because we'll already know what the new law that's going to come on the books is going to look like. So we can kind of factor that in. Does that help? Yes, sorry.
My sister and I own a vacation home in Wisconsin. She lives in Wisconsin, and she lives on a trust. We have plans to go to her 5 children.
Okay.
We live in Illinois. Do we need to have a current practice law in Wisconsin? Or have a license to practice law in Wisconsin? It's a trust to order. And my question came up with my mind here. Transfer on the map for a trust would be more advantageous in our situation.
Okay. So it sounds like there's two questions. One is for an out-of-state vacation home, which is sort of co-owned within the family. would you want to have an attorney licensed in that state to help you deal with that? And on that, I would say absolutely for administrative. If you need to sell it, you need to have somebody licensed to practice up there. And I would probably recommend that even on the planning side, if it's pretty simple, I mean, I'm not licensed in Wisconsin. Generally, I mean, I have done plans for out-of-state things like that, but it would probably help to get somebody who's licensed in that state if it's a complicated issue. And then, sorry, I distracted myself. What was the second part of that question?
Second part is, what would be more advantageous, a transfer on death or a trust?
Specifically for, so would a transfer on death or a trust be more advantageous for that situation? And was that, are you saying just limited to that vacation home or generally?
Specifically to that vacation.
Okay, yeah. So in the case of a vacation home that's kind of co-owned within the family, because that's a little bit more complex, I would probably recommend having that in a trust if you already have a trust. But a transfer on death could be, a targeted thing where you know that your share in that real estate would go directly to your beneficiaries. And it would depend on other things, but I would say both are probably equally valid. It probably depends on what the other aspects of your estate plan are. It would also depend on if Wisconsin has transfer and death deeds, which I'm not sure of. Yes, Rick. Yes, and so the question is if the other beneficiaries are planning on keeping or selling it, would that matter? It wouldn't really matter so much in terms of how you're going to set up the transfer to them, because whether they're going to sell it, they would have to get title either through the trust or the transfer on death instrument. So that's just a vehicle for giving it to them. But it does bring up a good point, because it's a huge issue with vacation homes, is that parents setting them up want to keep it for the family, but don't know if the kids are going to keep it around, if they're going to be able to pay the taxes and other carrying costs. So that can be an issue. And if that's an issue that you want to address, then in that case, the trust would absolutely be the way to do it. But I've seen a lot of situations where it's, everything's planned out perfectly, but then when it comes time to administer it, if they don't all get along, you can't force money out of their pockets to get along. You can't force those feelings of goodwill, and if one of them wants to keep it, the other doesn't. It can get tricky. So yeah, that's a great point. Yes, all the way in the second class row.
Yes, in 2013, both my wife and I had set up revocable trusts by a law firm, and recently we're thinking of changing some trustees and beneficiaries. So we've heard about something called First Amendment. Nothing's been changed yet. So can we, by ourselves, write a document called First Amendment and specifically point to the article, the paragraph number, whatever, change, then write out the entire text of what exists to what we want, have it notarized as official? Is that a legal document, or must we go back to the law firm? And does the law firm have to reissue that entire trust document?
That's a great question. So if you have a trust that's already set up and there's things that you want to change, usually when you set up the trust, you work with the law firm. If you want to amend that trust, because trusts are amendable, you don't have to have the same witnesses. All you have to do is sign it. You can amend your trust if it's revocable. So the question is, do you have to then go back to that same law firm, or can you handle it on your own? Is your amendment, if you write it up, if you get it notarized, is that going to be legal? Yes, it will be legal, and that's why I would tell you to proceed with caution, handling it on your own. If it's a simple thing, or even if it's not, whatever you sign is going to be a legal amendment, as long as you've got the ability and capacity to do it. If it's notarized, that helps provide evidence to a court or whomever else might need to take a look at it later on, that was you who signed it. So the notary helps to make it more official, but it's not legally required. And yeah, you absolutely are able to do that. But the malpractice thing would be, I would worry about, that there might be some unintended effects, but I would say, generally speaking, consult with an attorney. But to answer the very specific question, yes, it will be valid. You can do it on your own, and you do not have to get a lawyer involved to make it legal. Yes?
If you have a will, basic cut and dry, half to one child, half to the other child type thing, why does it have to go to probate?
That's a great question. So, so the question is, if you've got a straightforward will, straightforward situation where we're going to divide it, equally among the kids, then why does it have to go to probate? I completely agree. The issue is that probate it's sort of a clearinghouse. It's a public record. It's sort of one of those, byproducts of the whole, due process thing under the Constitution, where everyone gets to have due process of law. So let's say if there might be somebody who disagrees with you, somebody could come out of the woodwork and say, well, no, I was her good friend and she promised that she was going to leave everything to me, that those kids really never visited, they didn't love her anyway, so she must not have been in her right mind when she did that. That would be one aspect of it. The other would be creditors. That creditors are able to, let's say there was some end-of-life medical care that you weren't able to pay for during your lifetime, and they would have the legal right to present a claim to the probate court. So, and then the creditor issue is really why there's that 6-month holding period, that your executor has to publish notice to everybody. They kind of blast it out there to the world that, okay, here's this probate estate. If you want to, challenge the will or file a claim, speak now or forever hold your peace. And then one of the advantages of the probate is that it's a complete cutoff. So you can't come in after that 6-month period. Once it's closed, it's closed. And sometimes, even if you don't have to go to probate, it's a good idea so you can get that additional layer of protection. Even if you've put everything into a trust, you don't have to go to probate. If you do, then you can really have a nice cutoff and provide some assurance that there's not going to be anybody coming in after that 6-month period. Any other questions? Yes. Back again.
Okay, back to revocable trusts. Again, I mentioned previously, wife and I are thinking of changing some trustee names, which are relatives. What are your thoughts regarding having a trust company handling assets, house, everything else, for a fee, of course, rather than having children or relatives handling a tremendous amount of details? Is that advisable to have a trust company exclude relatives and children?
Yeah, that's a great question. So the question is, you've got a trust set up. What are the advantages, disadvantages for naming a trust company as your trustee instead of individuals? So instead of having your relatives who might also be beneficiaries, instead of having them as the trustee to carry out the rules of the trust, what about having a trust company? Not knowing the particular situation in detail, I usually recommend against that, just because it's a cost issue. So that they're going to charge a lot of money. There's one case I was working on, which I can't get into detail of, but the trust company wanted to come in and they were going to charge 3% annually of the trust balance. That was going to be their fee. So $1 million estate, you're going to be paying $30,000 a year just for them to serve as trustee. Yes?
Can I ask a follow-up?
Yeah, absolutely.
Okay, so if one engages with a trust company and the agreement is you don't have to do anything until both of us are dead, and let's say we both die 10 years from now, why should they get any money between now and 10 years from now? They're not doing anything.
Right, so yeah, and generally if you're alive and well, you'd be your own trustee of your own living trust. So, again, in most cases, if you're alive and well, you're the trustee, you're the only beneficiary. So just like if you didn't have a trust, you get to say, you know, you have complete say over what happens with your money. Same thing that's in a trust. Then if you're incapacitated, then, you know, your successor trustee comes in, steps into your shoes, acts as trustee. And then after you've passed away, your successor trustee kind of keeps on going. Does that answer
Well,
the question?
presumably, let's say both my wife and I die in 10 years, and then the trust company is named in the revocable trust. However, the mechanism is, and perhaps a trust protector tells them, hey, this couple, the last of them is dead, you come in for 3% of all the assets, and you administer getting rid of the house, everything else. So, for example, if you say $1 million, so 3%, that would be 30,000. They should be able to do it within a year or less. So 30,000 on $1 million is not a big deal, is it?
Sure. No, and that's why every situation is different, because sometimes there are good reasons that you want to have an independent trustee. Whether it's, you know, a trust company or, if, you know, again, if cost isn't an issue, then a trust company is probably the way to go. They've got expertise, they've done a lot of them, they know what to do. If cost is an issue, but you still want to have an independent trustee, you could have, you know, an accountant or somebody else handle it, who would kind of know how things get done. So, does that answer?
Yes.
Okay, thank you. Okay, and then last question.
My Roth IRA, is that excluded from all this trust probate?
Yes, great question. So it's the question is a Roth IRA excluded from all this probate stuff? Couple answers to that. First, it's part of your probate estate when it comes time to calculating if you owe estate tax. So it's part of your probate estate in that the feds will add up all of your assets, and then if they'll factor in that $4 million or $11 million, but it's not part of your estate when it comes time to figure out if you have to go to probate court or not. So usually with an IRA, you've got named beneficiaries. So when the time comes, then they would just take it on as an inherited IRA on the same basis that you do. It goes outside of probate. It doesn't even go into a trust. It just kind of goes automatically. They fill out change their beneficiary forms, and they're all set. And then they have the added benefit of then stretching out that time before they have to take distributions on that. Yes?
Could we explain the marital tax exemption?
Sure. The long and short of it is that you get a double up between a husband and wife. So in terms of the state exemption, you can each have an estate of up to $4 million. If you're married, then you get to double up, and it's $8 million between a husband and wife. Federal, same, it's from 11.5 to 23. Any other questions? I think there's some prizes coming up here. So if anybody has any other questions, I'd be happy to meet with you. I've got a booth over there in the gym at the resource fair. So thanks for your time. I appreciate the questions, and thank you.